over the weekend, border boss Tom Homan assessing the job performance of the border security boys and girls so far. So it's already a success. Obviously, there is much more to do, but he called it a success when 60% of 800,000 criminal threats have been removed. 60% of 800,000, that's almost 500,000. He also talked about the nearly half of the 300,000 unaccompanied minors that went missing who have been found in one way or the other by DHS, all of the individuals that are on the job here. One of the things that is a legal issue, in addition to TPS, the case adjudicated last week that we were by the Supreme Court that we were talking about earlier in the program, the temporary protected status designation and who has the authority to confer and withdraw. In addition to the birthright citizenship case, which we're still waiting for the Supreme Court's opinion in that case this week, next couple days, they're on the clock, next 2 days, today and tomorrow. We got to the end of the month, that's tomorrow. There's another issue too, and that's mandatory detention, such that you're in a position to prevent the problem from being exacerbated while you're dealing with the problems that you inherited from the previous administration. And this is in part governed by the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. Yeah, you know, the IRA of 96. Yeah, right. But it turns out to be an important piece of legislation because since the summer of 25, ICE has been taking a very aggressive position regarding who it deems to be, quote unquote, seeking admission, asserting that the mandatory detention provision in the law provides, I should say, applies to all non-citizens who enter the United States without inspection. And there's a lot of litigation surrounding the interpretation of the language in this statute that has significant policy implications. And to discuss those with us, we're pleased to be joined by Ilan Wurman, the Julius E. Davis Professor of Law at the University of Minnesota, and co-host of the Rationally Based is the name of the podcast. Professor Wurman, thanks for joining us. Appreciate it.
Dan, thanks so much for having me.
So distill the debate on mandatory detention and the implications if I did an insufficient job in any way.
You actually did quite an excellent job. So the whole issue was before IRERA. I'm actually not sure how people say that.
Yeah, it doesn't sing. Yeah, right.
Was that aliens who snuck past the border, right, who successfully entered the country illegally, were subject to deportation proceedings rather than, an exclusion proceeding. And so they had all these benefits. They were treated just like anybody else in the country who came lawfully, who had to be deported, rather than simply excluded. And so the whole point of IRERA was to diminish those differences. And the way it did it is it mostly got rid of this distinction, right, between exclusion and deportation, and created this sort of universal removal proceedings. And what it did is it defined anybody arriving in the United States, which was an issue, by the way, last week, the Supreme Court. It defined anybody arriving in the United States or an alien physically present who has not been admitted to be an applicant for admission. So that's the whole point. Like, obviously, someone who snuck in is not literally an applicant for admission, but the statute deems them an applicant for admission, whether, again, arriving in or physically present without admission, because the whole point was to treat them similarly. And then there's this detention clause that says an applicant for admission who is seeking admission, shall be detained. Sort of pending a determination of their immigration status. And the question was, well, wait a minute, are applicants for admission, are all of them seeking admission, or is it some like special subset, like only the aliens arriving in are actually seeking admission? And the point that I think the Trump administration has made, and the judges in favor of the Trump administration have made, is the whole point of the statute was to collapse the distinction between the two, that an applicant for something is necessarily seeking something. Again, they're not literally seeking it, but they're also literally not applying for admission. The whole point is the statute designates them as being in this category of persons who should be mandatorily detained. So although there are arguments on the other side, I think the Trump administration has a much stronger argument in this regard, as we've argued on our podcast, Rationally Based, as you said, than most people think.
So the point here is to say you have to make a distinction between someone who follows the lawful process and enters through a port of entry and does the application process as prescribed by law versus someone who breaks in, sort of sneaks in, as you say. And I mean, obviously, those two people are completely differently situated, and so the law should recognize that obvious distinction.
Right, and it shouldn't. The law should not benefit those who came illegally.
Yeah,
right.
Right.
And it's kind of interesting. So in your introduction, you mentioned the TPS case, or was it the metering case that you discussed last week? Well, in the metering case, right, this was the Obama-initiated policy, by the way, that Biden also continued, where they would stop aliens before they arrived in the United States. They would stop them on the Mexico side of the border so that they would not have to process their asylum claims. And one of the arguments that the liberal justices made in dissent is, well, wait a minute, this would incentivize illegal immigration, because now you are incentivizing people to actually sneak through and cross the threshold so that they will have arrived in the United States, literally inside, so that their asylum claims have to process. And they said that this is perverse. It incentivizes illegal immigration. Something that I sort of posted on social media was, I wonder if the liberal justices will remember that they said this when the mandatory detention case comes up, because the whole point is that the liberal side of that argument in the mandatory detention cases incentivizes illegal immigration. It benefits people who sneak in as opposed to arriving, at the border or port of entry and so on. So it's really interesting to see if they'll remember that they said that in the metering case.
Well, also the intent of the 1996 legislation that we were talking about, that is on point, that is relevant here, the statute, the Illegal Immigration Reform and Immigrant Responsibility Act. It was sold and heralded by Bill Clinton, who signed it into law, as cracking down on illegal immigration, and not just at the border, but in the workplace, in the criminal justice system, without punishing those living in the United States legally. But I mean, this was, as I said, sold and marketed as cracking down on illegal immigration. So if you look at the intent of the authors of the legislation and the President of the United States at the time, then that seems to be in line with the Trump administration's position as well.
Right, and our politics have changed.
Yes,
it's
well,
crazy.
true.
I mean,
right.
It was a bipartisan bill, and the whole point again was to collapse this distinction that had previously incentivized illegal immigration. So, like, all else equal. Now look. Okay, to be fair to the other side, I think their best argument here is they may have wanted to collapse all of these distinctions between between people who present without admission and those actually arriving, right? So it's snuck in versus those who have not snuck in. It doesn't follow that they necessarily wanted to detain people who had been in the country for like 30 years, right? That's like a different question. It doesn't necessarily follow. And one of the best arguments that they have is, if Congress intended to detain, millions of people, then, wouldn't they have provided for detention facilities for all those people and like a capacity? And they didn't do that. And in fact, they provided detention facilities under a different section of the statute and gave the secretary a power to waive, detention if there weren't capacity and so on. Now, look, that's a good argument. That's a good argument. The statute is super clear. On the other hand, it's not like, you're arresting 2 million people on the same day, right? It's like,
right. You're processing them through. Right. Yes.
So it's a good argument on the other side, but I think the Trump administration ultimately will probably overcome it when this case gets to the Supreme Court, which it inevitably will. I think the Solicitor General sought certiorari in the Supreme Court last week, So it'll be heard next term.
Well, I mean, the whole capacity issue, I mean, it's a bit of bootstrapping, right? So we just saw last week Alligator Alcatraz in Florida was closed, and DeSantis and Homan there saying, look, this was always
totally
temporary. So when we have a capacity issue, we surge capacity, and when we address the capacity issue, we can withdraw capacity. I mean, it's, we're responding as we need to based on the exigencies of the circumstance. That doesn't implicate some legal principle.
Yeah, look, you're preaching to the choir on that one. I get it. So one other thing that I do, in addition to being a law professor at the University of Minnesota, which you could see this makes me somewhat unpopular, is I sue
yeah, I bet.
I sue municipalities over homeless encampments because I think it violates public nuisance laws. Usually there's plenty of shelter available. These people have mental health, addiction issues, and so on that need to be treated, and just leaving them on the streets isn't good for anybody. And I represent sort of the residents and homeowners and business owners in these cases. But one thing that was really frustrating is that there are some jurisdictions that say, oh, we just don't have enough shelter. We don't have enough hotels. We don't have enough this or that. And it's like when the influx of migrants came under the Biden administration, it is amazing how quickly they were able to shelter and house millions of people. And you're telling me, in Berkeley, California, you can't get like a sprung structure up for 200 people? In this neighborhood, it's ridiculous. This is a manufactured problem, not just when it comes to these, immigration capacity issue situations, as you said, but in the homelessness context too. So it's absolutely bootstrapping, as you said. It's absolutely manufactured. And so, I get it, and I agree.
Wanted to get your take. I mean, while we have you, on the where the Supreme Court is going to come down on birthright citizenship and why, or more to the point, rather than handicapping, where you think it should come down on birthright citizenship.
Yeah, fair enough. So, as you may know, I'm sort of the one academic, sort of a serious academic, who has filed a brief in support of the Trump administration's position here, which again, contributes to popularity at my liberal institutions.
Yeah, you're really spoiling for it up there. Yeah.
I know, in Minnesota, like in the heart, but I love my faculty and they're my institution, and they're really, really good to me. And I wrote a long article questioning sort of the conventional wisdom on birthright citizenship. And the short of it is, that I've shown is when they said subject to the jurisdiction, right? The conventional wisdom is that this meant like criminal jurisdiction. Well, you can prosecute temporary visitors for crimes. You can prosecute illegal aliens for crimes. So they're subject to the jurisdiction, and therefore their children are subject to the jurisdiction. But what I've shown is the Indian tribes are subject to federal criminal jurisdiction. For example, in the 1817 General Crimes Act, in the 1885 Major Crimes Act. And nobody said or thought that the Indian tribes were included. So criminal jurisdiction wasn't sufficient. And they told us what was sufficient. They said by subject to the jurisdiction, we mean a complete jurisdiction, legislative, executive, judicial, the same jurisdiction that the country exercises over its own citizens. And I've sort of shown that Juan Camargue was rightly decided, arguably, because lawful permanent residents who are domiciled in the United States are subject to that complete jurisdiction. But temporary visitors, can you conscript them into the military? The Union military authorities in Louisiana thought you could not conscript temporary visitors or children born in the United States to temporary visitors, right? So there are ways in which illegal aliens may not be, and temporary visitors may not be subject to this full and complete jurisdiction. Now, will they rule this way, Dan? Oh, I'm not optimistic.
Yeah.
I'm not sanguine, but I hope. Okay, look, they can take a statutory off-ramp and just say, look, Congress in the 40s and 50s, when it enacted the immigration laws, used similar language. They believed it was broad. And so we're not addressing the constitutional question. I think that would be a win for the Trump administration to just take this off-ramp. Now, realistically, Congress would have to get rid of the filibuster to do anything about that, right? But maybe it should get rid of the filibuster to do something about that. But if they rule on the constitutional question, I think all of these justices grew up in a time when the conventional wisdom was very, very strong, and they, for 40 years, in their formative periods as law students and lawyers, they just believed that this was an easy question, and the conventional wisdom was open and shut. But at least for the next 40 years, they'll have the scholarship that I've contributed and others have contributed. So
it seems to me too that a favorite word of the left could be jujitsued against them here, and that's consent. I mean, you can't. This consent is a two-way street, and so without the consent of the authorities, as it pertains to your citizenship, it doesn't exist.
Well, it's funny you say consent is a two-way street. Something on the Rationally Based podcast that we talk about a lot is when they talk about things like democracy, it turns out you have to be very careful how they define it. So they define democracy to be a substantive democracy, by which they mean democracy under certain conditions. So we interpret this to be progressives get the results they like, that's democracy.
Right.
Progressives don't get the result they
Correct.
like, that's not democracy. So judges should impose it, and that's a proper democracy because the judges enforcing proper conditions of democratic self-government.
Yes.
So,
yes.
come on. You're not going to... I think progressives tend to lack the capacity for cognitive dissonance. They just don't understand what contradictions feel like for most people. Anyway, maybe I'm being a little too flippant with your audience here. But,
No, not at all. It's consent of the governed unless the governed get it wrong. Then we have to step in. Oh, I totally understand it. Ilan Wurman. He is the Julie C. Davis Professor of Law at the University of Minnesota, co-host of the Rationally Based is the name of the podcast. Professor Wurman, thank you as always for joining us. Appreciate it.
Thanks for having me. Bye-bye.
Bye. And you joined us on the alphawealthgroup.com answer line.
This is Chicago's Morning Answer.
Your show keeps me alive during the week. There's nobody I'd rather listen to between 5 and 9 in the morning than you guys.
On AM 560, The Answer.
On Salem News Channel, principled voices are shaping today's conversation.